So hello, everyone. I'm Nicole. I'm a continuing education coordinator for the Collaborative. And thank you so much for joining us today for a webinar by the Collaborative for Accountability Improvements Attorney Alliance. We are grateful to have all of you here to learn more about the important role for attorneys to enhance legal representation with communication and resolution programs. I would like to start by introducing Kyle Sweet, the chair of the Attorney Alliance and a partner at Sweet Law Firm. Kyle is an Oklahoma-based defense lawyer who represents healthcare providers in catastrophic injury cases around the US. Kyle teaches in medical schools, dental schools, and teaches seminars regularly to healthcare providers on how to avoid litigation by improving quality of care through more effective communication. Kyle also serves on the Collaborative's board of directors and looks forward to making CRPs the industry standard. Thank you so much, Kyle, for joining us today.
Thank you, Nicole. Okay, well, Nicole, thank you very much for that introduction. I have the pleasure of being joined today by two pillars of the CRP process, both from an institutional standpoint, and Rick Boothman. Rick is the principal of Boothman Consulting Group. He is the former head of patient safety and risk for University of Michigan Health System. He's currently an assistant adjunct professor in the Department of Surgery at the University of Michigan Medical School and a visiting scholar at Vanderbilt University Medical Center, Center for Patient and Professional Advocacy. Mike Severyn is a lawyer who, like myself, in a previous world was a defense lawyer until around 20 or so years ago. Mike went in-house and has been in the claims management and the professional liability insurance world. And Mike is presently the regional vice president for claims for ProAssurance companies. And Mike practiced in the defense bar in the Michigan area, in the Detroit area in Michigan. And we're very fortunate to have both of them involved. We're kind of all co-leading the effort for the collaborative with the Attorney Alliance. And we're real excited to have both these gentlemen with us today. So we want to go on to the next deal. We're kind of talking about some of the disclosures that we have there, and we'll move on to the learning objectives. And what we want to talk about today are, the role of attorneys in this Attorney Alliance that has been created as a program of the Collaborative for Accountability and Improvement. We are wanting to just basically explore how the role of lawyers, how it's critical to the process of the communication resolution programs, both from a plaintiff's attorney perspective, a defense attorney perspective, the role of lawyers in the risk funding mechanism of professional liability insurance, as well as institutional attorneys representing health systems and health law from an institutional perspective. We want to talk about the goals, work streaming, future opportunities, and what we want to build the Attorney Alliance out to be. So we're hoping this is going to be a collaborative kind of endeavor. And if you have questions, please submit them to through the chat function. And when we get to the end, we think we've reserved enough time that we can talk about questions and get some ideas and suggestions and thoughts from everybody who's in attendance today. So the next, if you can move to the next one, Nicole, this is kind of the context for the Alliance. The Collaborative for Accountability Improvement has as its core CRPs, which are communication resolution programs. And they're a model for supporting everyone involved in healthcare, including the patients, caregivers, academic institutions, and insurance companies, specifically when patients have been harmed by their medical care. Lawyers' traditional focus primarily on short-term risk and gain and the managing the litigation aspect of it can sometimes be incongruent with the institutional values that are in existence for exploring ways to more holistically deal with patient error that results in patient harm. And so we're hoping the Attorney Alliance can really be kind of a change agent for empowering lawyers to have an ability to impact this process and not be an impediment to their own clients on the defense side wanting to explore their medical ethics, as well as on the plaintiff side wanting to explore early resolution and a better understanding transparently of what happened with their loved one's care. So we're hoping that this is something that will challenge the status quo and create a new process that allows lawyers to deliver on their ethical obligations to their clients, as well as explore the potential of a new legal practice area. So we can move on again, Nicole, to the Collaborative for Accountability Improvements Alliance is enhancing the legal representation within CRP processes. And so our goals and purposes are to form an association of lawyers interested in leveraging the foundational values of communication resolution programs, advancing our clients' interests, meeting our own ethical obligations, and allowing our clients in the context of healthcare providers to meet theirs. We have to have the involvement of plaintiff attorneys as well as system attorneys to really make this work. And it's unusual that defense lawyers, plaintiff lawyers, institutional attorneys will all come together to try to work towards a common goal, with involving transparency and ultimately improvement of quality of care and the experience that our respective clients has when medical error has resulted in patient harm. So we're hoping that this Attorney Alliance will be a resource for attorneys, eventually a certification process. We'll talk about that here in a little bit as well. And we have some large goals that we want to share, and we have committee structures, and we'll talk ultimately about ways that we can involve people as well. So moving on, I wanted to involve Rick and Mike at this point and talk about specifically kind of drill down on some of these objectives and the way we're doing it currently with our best practices, innovation, professional development, education, and then resources and additional functions. So Rick, you want to take it away and kind of describe everybody what you're doing in the best practices and educational realm of the Alliance?
Yeah, thanks, Kyle. I want to take a step back and remind everybody that much of this started with Steve Cramen and Ginny Ham, who wrote in 1999, it seems like a lifetime ago, their article in the Annals of Internal Medicine, an article called Extreme Honesty. And they talked about the approach that they had followed in the Lexington, Kentucky VA health system, where Steve was chief of staff and Ginny was the resident attorney. It was a remarkable piece of literature that opened the door to this model. We followed shortly thereafter at the University of Michigan with what became known as the Michigan model. But since then, academics have come to call this the Communication and Resolution Program, or CRPs. There are some essential elements to this approach that set it apart from cherry picking select claims resolution for early resolution, or select claims for early resolution. That's not in and of itself a new process. But what this looks like changes and is tailored to every single organization. What we really want is not to be mired in Steve's and Ginny's experience or in our experience at the University of Michigan, but actually start kind of an engine for creativity. And how do you take the essential elements and expand them out over different venues, different groups? We've got people already interested in using CRPs in just multidisciplinary physician groups. There's differences between community hospitals and self-insured organizations, those sorts of things. So one of the things we want to do is be an engine for innovation in best practices. Next, in the professional development and education. You know, when I retired from the University of Michigan to start my consulting business in 2018, the head of public relations said to me she had never seen a positive story so durable. That for 18 years, the University of Michigan continues to get inquiries and positive press on this. The point of saying that is this is durable. This is real. And educators in all sorts of areas, not just legal, but definitely in legal and law school educators, need to pay attention to that, should be rounding out that education with knowledgeable information on CRPs as an important approach. And I would say it even transcends law schools. This year alone, I've spoken to 2 undergrad groups and public health school in addition to 3 law schools. So we want to provide, and more on these 2 things as we get into this presentation, but we want to provide resources and a place where even educators can come and bring their creative ideas and understand this approach and see the benefits of it. Mike, you're going to talk, I think, about resources.
Yes, thanks, Rick. Again, as Rick said, one of the huge objectives of the Alliance is to be a resource for attorneys, patients, healthcare providers, and healthcare systems. For example, at the Alliance, we want to develop lists of attorneys, including plaintiff attorneys, defense attorneys, and in-house attorneys who are committed to and trained in CRP practices, procedures, and concepts. We also want to develop lists of arbitrators and facilitators and mediators who are committed to and trained in CRP practices and procedures and concepts. Another objective of the Alliance is to promote CRPs. For example, as Rick mentioned, we want to work with law schools to help train young attorneys on CRP practices, procedures, and concepts. We also want to advocate and support CRPs by publishing and promoting CRPs in legal and medical journals. We also want to advocate and support CRPs by putting on webinars and seminars and podcasts that promote CRPs. And finally, at the Alliance, we want to actively look for financial sponsors to help support the Alliance and the Collaborative for Accountability and Improvement in supporting CRPs. These are some additional objectives of the Alliance. Kyle?
Yeah, thank you for that, Mike. And just to kind of dovetail to that a little bit, we are our structure is such that we're the overseer of the Collaborative for Accountability and Improvement is currently our board president, Dr. Eric Thomas, who is with the University of Texas Houston branch. And Dr. Thomas, I believe, is serving a 2-year term. And the Attorney Alliance there's an oversight committee that I chair, and then we have best practices committee that is chaired by Rick Boothman, our development committee by Mike Severyn, and our education committee also is at this point is by Rick Boothman. And then we have a TBD on the nomination committee because we're still so new in that process. So that is the connectivity we have to the overall Collaborative, who serves as an organization who's attempting to spread the use of and the clinical importance of communication and resolution programs to hospitals all over the world, really. And the Collaborative has partnerships with different organizations such as Ariadne Labs, which is a joint venture between the T.C. Chan School of Public Health at Harvard and Brigham and Women's Hospitals, and they scale up, healthcare related change in programs and policies and scale them to help make them essentially standard of care throughout the world. So we're very fortunate to have a relationship with Dr. Evan Benjamin and Ariadne Labs as well. And so the board for the Collaborative is comprised of kind of thought leaders in both patient advocacy, and we have plaintiff attorneys, defense attorney, many people from health systems, and as well as professional liability carriers, hospital associations for various state organizations. And so it's a really an amazing group of individuals who are really committed to making this standard and scaling it throughout the United States. So the next section we want to talk about is kind of the opportunity for all types of attorneys to drive the CRP field. And the first up is our brothers and sisters in the plaintiff bar. We have a wonderful attorney who kind of represents the interests of the plaintiff bar on the Collaborative, Jeff Catalano from Boston, who's been really integral in he's from the Massachusetts has a program that is really kind of the envy of a lot of states, the macrame. And so Jeff's been a real leader in his region for communication resolution program type activities, but that are legislated and created as law in the state of Massachusetts. So essentially, what we want plaintiff attorneys to understand is this is a big tent and a big table, and for CRPs to reach their true patient safety and quality benefits and objectives is we have to have the involvement of everybody who's a stakeholder, and plaintiff attorneys are an incredibly important stakeholder to this process. We are hoping for, we have out there was on the slide, it says CRPs are here to stay, and Rick talked about the durability of them. What really impresses me is the inevitability of CRPs as healthcare finance moves more and more towards a single or fewer payer model. These types of programs really don't become just aspirational. They become practical, and they become things that are inevitable. And so 100% transparency goals on unplanned clinical events becomes easier when you have fewer and fewer payors. And the attorney responsibilities and duties under the ABA model rules of professional conduct are really truly met. And so as a patient advocate attorney, you should be well versed in CRPs because it's going to be an increasing area of your practice in years to come. The next, and arguably, and this is like being coached by your dad, you know, you're going to be harder on them than anybody else, is the defense attorney section. And that's the world that I come from. And both Rick and Mike come from this world as well, because Rick and Mike have both tried cases like I do in their previous life as a defense lawyer. And one of the things that we see, and the reason for my involvement in the collaborative as well as the Attorney Alliance, is attorneys, particularly defense attorneys, we're the ones who people turn to say, you know, our clients directly, if it's a physician or healthcare provider or an institution, to say, hey, is this something I should be involved in? And our instinctual training and our intuition says, no, absolutely not. Circle the wagons, deny any liability, don't let anything be used against you, and let's go litigate this, because we always have a way of making the case, you know, better for us. And that really does fly in the face of our ethical obligations to explore doing things in our client's best interest. And Rick said something a while back that's probably months ago that's really stuck in my head, that's changed the way I view my conversations with my clients. And what he said was the first, and I agree with this and adopted it as my practice, the very first question I ask on a new case or a new client or a new matter is, what is important to you? What values do you have that I can assist you in meeting? And when you have that mindset, it changes the dynamic of your relationship with your client, your insurance company. And from the defense lawyer's perspective, I think that is something that we need to start asking ourselves, because what we're going to find out is our business model as defense lawyers is not necessarily in the best interest of our respective clients, who may want closure. They want exploration to keep their healthcare providers active and engaged in healthcare and not burnt out, and litigation burns them out. And so defense attorneys can be a great impediment. And by use of the Attorney Alliance, we feel we're going to be real partners with health systems and healthcare providers in going through a process they're going to come out of it better on the other side, and have a longer, more satisfying career in healthcare. So next, we want to talk about from the perspective of insurance company counsel and the claims process. If you can kind of share your observations on that, Mike.
Sure. Thanks, Kyle. And again, I just want to add one more thing about defense attorneys. You know, just an observation. Many healthcare providers are on staff at healthcare institutions that require them to participate in CRPs and disclosure programs. And thus, again, if you're going to be a defense attorney who specializes in representing healthcare providers, you need to be well educated and skilled and trained in CRPs. And if you are, it's going to present many opportunities for you. Health insurance companies or professional liability carriers are going to assign those types of cases to attorneys that are specialized and have education and training in CRPs. As it relates to in-house counsel, CRPs also create a lot of opportunities for insurance companies, attorneys, or in-house attorneys, because again, the trend nationally and regionally is to have CRP programs at healthcare systems where staff, the providers, are required to participate in CRPs and disclosure programs. If this is the national trend, the regional trend, then again, it's extremely vital if you are in-house counsel or insurance company counsel that you are well educated and trained in CRPs. Furthermore, one observation, you know, the model rules of professional conduct require attorneys to be competent, prompt, and diligent. They also say a lawyer should seek improvement of the law regarding the access of the legal system, the administration of justice, and to seek improvement for the quality of legal services rendered by the legal profession. With the rules of professional conduct in mind, one can make a very, very strong argument for any attorney who's going to be specializing in representing healthcare providers or healthcare systems in this day and age. You need to be highly versed, well-educated, well-trained on CRP processes, procedures, and concepts. It's absolutely vital. Rick, you want to talk about academia?
This happens to be one of my favorite topics. Dave Mayer, now at MedStar, but I knew Dave when he was at the University of Illinois, an anesthesiologist, always would say, you control the old, but train the new. I think what he really meant was restrain the old and train the new or the young. This is especially true in academics. This process has not only proven to be durable, and as Kyle says, I do believe that it is inevitable. But there are so many benefits to it that have not yet been explored. More and more academics, more and more teachers are feeling the need to round out their training, not just of future litigators, but also of health law lawyers, HR lawyers. There are a number of other possibilities. People involved in regulatory kinds of pursuits or interests, even business lawyers need to understand the CRPs. The research and publishing opportunities are amazing. The Betsy Lehman Center in Boston did some really groundbreaking longitudinal studies just of the benefits to patients who have been harmed in the course of their medical care and who have now, because there's enough of them to study, who were treated with compassion, with honesty and transparency, instead of experiencing the brutal experience of litigation. The comparison is striking. Those people who went through a CRP-like experience rather than a litigation-like experience report that they rebound far faster. They still carry the scars. We talk about resolution, and I've been told more than once by patient advocates that there really is no resolution, but to be able to process the bad things that happen really matters in terms of how they're treated initially. Academics and researchers are now starting to explore those things. I'm working with researchers right now on the whole question of disclosure when you're aware of somebody else's mistake, and what kinds of rules and what kinds of guidelines should we be looking at. So the research and publishing opportunities abound, and not just in law schools. As I alluded to earlier, I have now spoken with public health programs and healthcare administration programs, but also at business schools, undergrad programs, and most recently, the philosophy department at the University of Michigan, which for 4 years has actually featured this whole concept, not only in their undergrad training, but in the PhD level training. So I don't want to lose that. I think that the academics can bring not only a lot of study and publishing possibilities, but a lot of creative thought to this. Nicole? And health law lawyers, I think, often get overlooked. We tend to think too often and too narrowly about CRPs as a litigation mentality. It's far deeper than that. What sets this apart from early claims resolution practices that were in place when I became a lawyer in 1980, what sets this apart is the organic look of it. The question, as Kyle said, of even a defense lawyer asking, how do I best serve your mission? How do we work toward your clinical mission? Because defending care we're not proud of may be possible, but maybe counterproductive in the long run. Well, the same is true with health law. Health law lawyers, of course, are usually not litigators. They're looking at regulatory compliance and statutory norms. They're looking at things like peer review, patient safety and quality, architecture. All of those things can be complemented by and learn something from the CRP environment. And it's something that we need to look at. Not long ago, I gave a talk, but I followed a lawyer, a health law lawyer, who talked about her fears about things like patient safety organizations. And I was stunned at the narrow-minded look of that. We tend to be too risk averse and not, and we don't ask ourselves often enough, what actually benefits medicine, what actually benefits our clients in these settings. So I think that there's ample opportunity here to expand on these things in the health law field as well.
Yeah, that's a great, Rick, what do you think about as healthcare payments and reimbursements are being tied to quality? Does that have any impact, you think, on the importance and long-term viability and inevitability of CRPs?
Well, yeah, we're going to, obviously, with healthcare costs in the country going through the roof, there are actually a number of things that CRPs impact directly on those reimbursement models. Just to digress a minute, one of the greatest compliments I ever received was an indirect compliment when the head of maternal fetal medicine at the University of Michigan was being interviewed, of all things, by Great Britain's news service. And he was asked, how has your practice changed? And he said, I don't practice or I don't teach defensive medicine anymore. I teach evidence-based medicine because I know that I'm now supported by an organization that is principle-based. That came right out of a CRP. That will change a lot of things. So yes, reimbursement now based on quality clinical outcomes is going to be part of it. And the more we as attorneys can emphasize the clinical mission and support quality and safety rather than defend care that we're not proud of or hide mistakes because we can't improve if we do those things, I think that's going to fall right into that, that reimbursement, or it's going to mesh well with changes in reimbursement.
And one other thing on that too, I think a lot of us, any of the people who are who are watching this today, probably have some experience with hospitals, healthcare systems, attempting to do something similar to a CRP, kind of like a poor man's version of a CRP, or attempt to be transparent, but they do it in kind of an ad hoc fashion. And one of the things that's so important about the CRP process is it is just that, it is a process, and the experts like Rick and Mike and the people involved with the collaborative, it's more than just, oh, we'll figure it out when one of these comes up. The time you don't practice a CRP once it's going on. You know, you practice excellence. You practice by having this process put in place for your facility, your institution, your system well in advance. And so you make sure that you're having the right people doing the disclosures and the right people involved as the family liaison, and how you're going to interact with the plaintiff attorney who may be brought along through this process. And so it's a lot more complicated than just, oh, we'll just talk to the family and keep them advised in a traditional risk management format. It can kind of, it is very much a niche that needs to have the right people at the right time, properly trained, properly vetted, because the wrong person doing a disclosure, for instance, can damn the entire process that happens subsequently. So the beauty about it is you don't have to reinvent the wheel as a system. You can literally work with the collaborative, and your lawyers can work with us in the Attorney Alliance as we're initiating some education resources and things of that nature. Because in my experience, I've seen a lot of people say, oh, I have something similar to that. When we have a bad outcome, we kind of try to do this on our own, and it doesn't work. It's not very successful. So your likelihood of being successful, if you have a CRP process in place and the people who are properly trained, I think goes up significantly. Can you kind of comment, Rick, on your experiences with some of your clients as well as your institution?
Well, the first thing I'll note is that those folks who do this in a cherry picking way are missing the point, because they are still seeing this only as a claims management strategy to be employed whenever it's convenient or inescapable, rather than seeing it as far more organic and part of the mission critical, as Tom Gallagher so aptly termed it in a British Medical Journal piece that we wrote. So what you're describing are folks who still don't fully understand the difference between just an early claims resolution process to be trotted out when they have to versus not. The other point that you made, which is really true, you don't want to try this, or you don't want to pioneer this in the midst of a crisis. It takes careful thought. It doesn't, I really believe every organization can do it tomorrow, but it's a mindset shift as much as it is a training and a preparation kind of a thing. When we started at Michigan, for instance, I reached out to all the plaintiffs' lawyers in the area and sat down with them. I took many to breakfast and said, but independent of a case, and said to them, you're going to see something different coming forward. And of course, they were all skeptical, but it was important to start that conversation. It's a community, and we're all in this really to do the right thing across the board. But yeah, that what you said, Kyle, is very important.
Well, and I think what you mentioned about reaching out to the plaintiff's bar is critical. And otherwise, you're going to constantly be fighting this same battle, just like as a facility would with their defense lawyers. You know, you got to get them. If you're the facility, you drive a lot. You can drive a lot of change in the way your defense lawyers are practicing. Mike mentioned it, that they're not going to want to be working with a firm that doesn't have the resources to be able to provide the service. And so, and part of that is having a good working, transparent relationship with plaintiff attorneys and letting them understand, come to this attorney alliance, you know, there's a place for you here. And it's not just for defense lawyers and in-house lawyers. And for it to work, we have to have, like I say, a big tent and a large table. And part of that process is mediators and arbitration, Rick, and that's something maybe you and Mike can both talk about a little bit, is the role, the increasing role that mediators can play in this process, as far as even understanding it and so forth.
Well, it's so I've been mediating in between hospital projects, and I'm struck by the prevailing mentality in mediation circles that I've seen tends to be shuttle diplomacy, tends to be kind of scare tactics on both ends and try to get everybody toward the middle. Mediating with an organization or a plaintiff's lawyer that embraces these principles is different. When I was at the University of Michigan, we really were very choosy about who we used when we needed a mediator, who we would use for that. Because when you come to the table in a principle-oriented way, you're not inclined to do nuisance settlements on cases that are groundless. You're also not inclined to steal a case, because you recognize that stealing a case only teaches your large caregiver or audience that's watching you that you can cut corners, hurt somebody, and get away with it. There's a real paradigm shift that comes, and most mediators are not prepared for that. At least that's been my experience. So it's maybe 1 in 20 that understands when you come to the table and you say, we are here out of a sense of principle. We're here out of a sense of our clinical mission. We're at the table for a reason. And that credibility takes a while to build in a environment that has been largely games for a long time. There are also opportunities for mediators that I think we haven't explored very much. It strikes me as odd. Almost every case that happens, the defense comes to the table already knowing if they should be proud of the care or not. A lot of things have happened behind the scenes to investigate the cases. They don't need lawyers in a courtroom to tell them if they've screwed up. What they need lawyers historically to do is tell them if they can get away with it. Or they have to defend themselves. Why not come to the table in a very transparent way? There is a role for pre-litigation mediation. There is a role for a mediator, and it changes the role of the mediator from shuttle diplomacy to more of a referee to kind of oversee sharing of information that is necessary for both parties to make sensible decisions about a potential claim. Arbitration is the same thing. I have arbitrated a number of cases. Too often, it felt like it was really mediation. Arbitration with CRP principles behind it is a very different animal. So the point is, there's a lot of room for talking with mediators. There's a lot of room for educating mediators. There's a lot of room for creativity with mediation in this process.
Yeah, and I can just add that, again, mediators pre-litigation can be very, very valuable in the CRP process, because, again, if done correctly, they can bring great credibility to any offers or demands in particular cases, because again, lay people sometimes, whether it be a hospital system or a healthcare provider or an insurance company on behalf of a healthcare provider or health system, when they offer money, a lot of people think, well, why are they going to be fair? But if you have a credible mediator pre-litigation who can describe the process, who can authenticate the CRP process and the offers and demands, that can help go a long way in resolving the case pre-litigation.
Mike, you put your finger on a really important distinction. If you're embracing a CRP principle, you come to the table with a genuine evidence-based idea of what the harm is worth. What is the value of the damage that the mistake caused? Early in my experience, I offered on a case $1.75 million before there was even a demand. And it sent apparently all the wrong signals. So the plaintiff's lawyer, who had known me for all through my litigation career, thought that I must have lost my brains, that if I was already offering $1.75 million on a case without even a demand, I must have a ton of money in my pocket. We ultimately settled that case for $1.8 million, but I had to go through demands of 20 million, 16 million, 10 million, until we finally sat down and said, no, I don't think you understand this approach. The plaintiff's bar gets it eventually, but we're all so attuned to the gamesmanship of the courtroom that the CRP process and the CRP principles change things, and it does warrant some time to spend with mediators who can help in that process. Because you're quite right, the credibility that a mediator who understands where you're coming from, the credibility that person imbues on the discussion makes all the difference in the world.
Well, I think one of the keys is, at least in my experience, and you hit on it earlier, Rick, is you have to divorce yourself from this is a claims management model. And this is something that is a different thing altogether. There are areas of overlap, and one of those is valuation of the loss, valuation of the injury. And in my experiences, when you're married exclusively to the claims management model, and you try to do early resolution through a CRP process, it kind of bleeds over into, I expect a discount because I want an institutional discount because I'm coming to you early before you're going to have to pay all of this expense. And isn't that good of me? Please pat me on the back and give me a significant discount. And I think when you look at it from an ethical standpoint of quality of care and trying to be transparent and fairly compensate someone for what happened, then it becomes more of the mission critical aspect as less of a let's focus on a claims management, let's reduce payments, let's reduce expense. And it's important to understand the CRPs in their proper context. And it is not, like you mentioned before, it is not just a function of the risk financing. It is a function of the integrity of the healthcare providers in meeting their ethical obligations as caregivers. And for attorneys, we're going to have to change and have a paradigmatic shift in the way we view our role as well. And we're going to have to divorce ourselves from living exclusively in that my job is to, and my attaboy comes from saving my pay or money. You have a new attaboy that comes at you, which is helping my client get through this process in a way that is as satisfying as it can be. And ultimately, in my experiences, when you go, and Mike, and I'm sure you and Rick can both talk about this too, when you go and you complete a trial, and I just got out of a quad case last week, and it was a long trial and we won, and you go and you have a cocktail with your client or whatever, it's visible on their face how unsatisfying that victory is. They're not high fives and pats on the back. You feel like it is a intense relief, but it is not a celebration. And that's one of the things I think that can drive all of us towards really getting behind the mission of CRPs, and it not be paying lip service to our clients because we want to tell them what we think they want to hear. It really is an incredibly satisfying endeavor to not only build a new practice area where one historically hasn't existed, but also be doing the right thing for your client, because we're facing with COVID historical dissatisfaction with healthcare of our client providers. And this is a way that we can contribute towards retention of really excellent people. And all people make mistakes, lawyers included. And it's much more rewarding to be involved where you're getting the client through a process and to a place where they can move on and not have this living with them for years, where they know in their heart of hearts that they may have made a mistake. And yet we have an entire infrastructure, an entire industry that's built towards preventing them from reconciling with that mistake.
Well, and so I want to make 2 points, but we have a question that I think is perfectly timed. And the question is, doesn't the healthcare organization need to hear from the patient before it can properly value a case? Absolutely. More, and I would even add to that. So whenever I do training in organizations that want to make this transition, the very first thing you learn is that you listen. You listen first. I love Stephen Covey's admonition, seek first to understand before you seek to be understood. We trained, and I right now train all of our risk managers to engage patients as quickly as possible after the harm or families. And the first thing you do is listen. And you not only listen to the harm that you've created, you not only gain an understanding of what everybody is going through, what the new medical needs are, so that the patient can make better future decisions, but you also hear key information that may never show up in the medical record. So how can you investigate an episode without hearing from the people involved, especially the key person like the patient? So thank you so much for that question. The second point I want to make is just a plug. We happen to have, on this point, we happen to have Tom Giroulo, who is a nationally known mediator on one of our committees, who can talk about the whole paradigmatic shift from a CRP and valuing an injury on an evidence basis rather than on a horse trading basis, as we have historically. So I'm glad for that discussion and very glad for his involvement.
Absolutely. And also Beth Kay asked that question of us. And one thing, it's a great question. Thank you for that, Beth. And on that point, I've seen a real shift, and I'm interested to see what Mike and Rick have thought over the last, I'd say 10 to 12 years. We have gone completely away. And this is just another example of the different value systems about, mediation in the context of litigation or even pre-litigation compared to the context of the CRP. We have gone completely away, and mediators are mostly, I think in some ways, to blame for this, but they don't want opening sessions anymore. So my first 20 years practicing law, every mediation had an opening session, and we could communicate directly to the patient and their representatives and the family, and we could tell them, we're terribly sorry this happened to you. We're here to understand, what it will take to resolve this case. And well, I think we've deprived ourselves of an opportunity to listen to the family members, and because we would get entrenched, is what we were told by mediators. We can't have an opening session because we're going to wind up, further entrenching, and we need to basically keep things fluid. And like what you said, Rick, is spot on. It's the horse trading. If I get you guys talking without me present as the mediator, then or with me present, but you guys directing the conversation and listening to one another, it's going to, perhaps, make my role a bit less significant. Mike, have you seen something similar in a lot of the cases you have where mediators are not wanting opening sessions where everybody gets together and discusses kind of their take on the case?
Absolutely, Kyle. And again, to further elaborate on the listening, not only do you want to listen to patients about their injuries, about the outcome, but listen to the providers. I conclude with one kind of real quick war story. I was involved in an incident a couple of years ago. The state that was involved is irrelevant, but a physician called me up to report an incident. There had been no lawsuit filed. She was devastated. She was crying. She was totally upset. On the day that she called me up, she had found out that either her office or herself missed some lab findings that would have diagnosed ovarian cancer, and she was absolutely devastated. And if I would have gotten that phone call 20 years earlier, I probably would have told that doctor, do not admit to any mistakes. But I was, I felt horrible for the physician. I felt horrible for the patient, but I also felt good because I had been trained on CRPs and I knew exactly what to do in this incident. I was there to be able to support the doctor. Going back to your comments, Kyle, about attaboy, attagirls, I felt so proud that I could help this doctor out and advise her on what to do, what to say. We were able to help out the patient. We were able to get that patient to cancer care specialists. We were able to help the patient's family out by offering some genetic testing to the patient's daughters to see if they were at high risk for possible cancer in the future. We were able to support the doctor in her time of grief and upset. I mean, she was absolutely devastated. She was a physician who on a national level had been involved in a bunch of seminars where she basically was saying that internists should never miss the diagnoses of ovarian cancer, signs and symptoms, that kind of stuff. And to have this happen to her was traumatic. And we were there to help her out. And more importantly, we were able to resolve the matter, sort of any lawsuit. And again, this was good for the patient's family, for our physician. We didn't have to put her through any deposition. It was good for the healthcare system. And last but not least, we were able to identify some practices and procedures that the office could institute going forward where this would never, ever, ever happen again. So that was a win-win for everybody, attaboy, attagirl. And that is the dynamic of where things are changing with the future of healthcare, in my opinion. I mean, again, now more than ever, health systems, physicians, they need us more than ever. Doctors are stressed. Healthcare systems are stressed. Patients are stressed. This is our time as attorneys, as professionals in healthcare, to be leaders, to shine. This is our time.
Mike, that's a great point. And one thing along that lines is I think exciting for me, and of course, Rick and you have been involved in this for quite some time, but is it changes whether you're a plaintiff attorney or a defense lawyer. You can really, through a CRP, through the embracing of the CRP process and getting involved, educating yourself about it, and hopefully delving into, working with the Attorney Alliance, and as we build out, certification processes and different types of continuing ed, the rewarding aspects of being involved in the improving of healthcare, as opposed to only defending healthcare. It really opens up a different world to you from a practice standpoint. But more importantly, it really, I think, demonstrates to your own clients that your willingness to get them through something that is ultimately better for them. And putting your own client's interests above your own should be the very first thing we as lawyers, despite who you represent, we should all be able to agree on. Is that this is a fiduciary responsibility that I have to my client, be it a plaintiff or a system or a provider. And I take that fiduciary responsibility seriously. And if I have an opportunity to better myself and expand my practice and offer CRPs as a practice area for my clients and help them develop CRPs within their own institutions, then you're going to see that the rewards of participating as an attorney in improving healthcare for all is something that is really difficult to get just by going and winning a case. And it'll change. Last week was the first case I tried during COVID, and it was the first opportunity for me to kind of institute some of these changes in the way I do jury selection, and particularly post-verdict interviews. And I asked a question I've never asked before, and that is there anything you can think of that you, from a layperson, would have thought it would have been better healthcare provided by my client? And I had a long conversation with several jurors about, record keeping and repeating of, aberrant, lab value testing and things of that nature. And so it was really a glimpse. And I shared that with my carrier as well as my client to say, hey, just, I know we won and we're all excited about that, but just from a quality improvement standpoint, here's something that can be considered. When you're in the CRP world, that is the world, is improving of healthcare, improving the quality of life for the healthcare providers as well as the patients. And so what Mike said is really spot on, and that is that the Attorney Alliance need to be leaders. And for CRPs to reach their full potential, it really needs to have lawyers who are committed, educated, and involved in that process. So as we're kind of one of the things that talked about, I wanted to get your take on Rick, is moving from micro to macro in CRPs and what the Attorney Alliance can do to help people move from a macro or from a micro understanding to more of a macro in the context of this in a big picture.
Let me address the micro first, because both of you talked eloquently about some of the healthcare improvement benefits, but I want to get more personal. There is not a single person who goes into medicine for the money. They may get jaded at some point. It may become something later on in their career that is a priority, but there are far easier ways to make money than in medicine. I truly believe that we are dealing with a population of caregivers who find meaning for themselves in helping others. Just as profound, if not even more profound, are the patient's perspective. Think about the act, what a statement of trust, often blind trust it is, when you give yourself, you give your loved one over to sometimes an entire stranger and put their lives in someone else's hands. And the sense of betrayal that can happen when things don't go right in this inherently risky endeavor is profound. The refusal on our part to see this in personal terms, rather than just seeing it in the financial terms, but failing to attend to the personal needs of both caregiver and patients, I think has been a mistake. And I have seen more unbelievable acts of generosity and grace happen when, and nobody wants to do it. Everybody's afraid to get together in a room and face each other. But when they do, and when you give patients a chance, when you give caregivers a chance to explain themselves or to talk about what happened, it's an unbelievable experience. I loved my practice as a trial lawyer for 21 years. I wouldn't trade the last 18 or 19 for anything, because it created a value for me to see that grace and to see those profound acts of generosity that most of us never see in our lifetime. On a macro level, when you stand back and think about it, how often have we defended care that everybody knew on our side really wasn't great care? And you see the same clinical problems over and over. Sometimes you see the same clinical characters over and over. I made an awfully good living on the same kinds of clinical mistakes that nobody was learning from, because the deny and defend mentality treats everything as a one-off. That these are hardworking practitioners working in an inherently risky activity, and when something goes wrong, it doesn't necessarily mean that anybody made a mistake, which is true. But sometimes it does. And sometimes the greater good is to confront that immediately with honesty. Not sometimes, always. The greater good is to confront it with honesty, transparency, and proactivity, and to get out in front of it. So all of us, whether it's a healthcare lawyer or a health law lawyer or a litigator, or even a healthcare administrator or a patient, we can all make a difference here, because we've seen the damage and the harm that litigation causes. As you said, Kyle, I've never tried a case and walked away feeling great, even when I won. I might feel justified and validated, but at the university, we got to the point where if we were forced to try a case and we would win the case, we've actually viewed that as a failure of our process or our ability to make people understand that we didn't make a mistake right up front. So it's a very different mindset, but that macrocosm, to be able to talk to each other in a way that we don't anymore societally. I'm sorry for that. change that we've seen socially, but we have it within our power to actually change that. And the permissiveness, the permission that we as lawyers can give to caregivers to say, it's okay to talk to them. It's okay to express how you feel. It's okay to defend yourself and to explain why this was not negligence. It's an amazing power that we have, and that we need to pay more attention to that.
Rick, that's a great point, and we're going to have to. We got a few more minutes left. We want to get to the next slide and opportunities to get involved, and we want to leave a few minutes for some questions. We are seeking partnerships with law firms, both plaintiff and defense firms, for financial support. We are seeking people to join one of our growing committees, hosting continuing ed presentations, introducing your clients or attorneys to the CRP process, and sharing resources. So we want to create a network through the Attorney Alliance, resourced by the Collaborative for Accountability and Improvement, to really be there for our clients all across the country. So for more information, you can contact the CAI at uw.edu to learn more. We really appreciate everybody's time and being involved in this today. There's some, looking through the people who are in attendance, we have some amazing people involved who are participating today, and we really appreciate it. So looking at some of the questions, if anybody has any they want to unmute and ask a question, that'd be great. I'm trying to read through some of the chats if Mike or Rick want to look through those. Attorneys are leaders, and as other stakeholders, hospitals, physicians, et cetera, see attorneys become more comfortable with CRP principles, it will positively influence more uptake across healthcare. That's macro. Thank you all for your passion around this topic. We thank you, Dana. And any other questions, please feel free. We have a question from Beth. Will the committee be working on models for how plaintiff lawyers and lawyers representing organizations would be compensated in a CRP context? That's something we're certainly exploring. That we're going to seek our guidance from that on the Collaborative. This is a new endeavor, Beth, that we're embarking on, and things like what you're suggesting are critical to it being successful to the end users. So yes, we are completely open to that. And that's going to be something that's going to be important going forward, is as legal fees get compensated differently in the future, as the legal business changes, that's something we're going to have to be responsive to. So yes, that is something we're interested in. All right, well, we have at the end, thank you for all of that.